I am Nicola Phillipson. I'm a barrister at Park Lane Plowden Chambers in Leeds, and I specialise in probate and inheritance matters with a side order of trusts. And when I say I am a probate practitioner, I'm using the word probate today in a completely non-technical legal sense. And what I mean by that is I deal with all of the stuff that happens when and after people die. And sometimes before people die. I have actually had someone challenge a will before the testator was dead. But this work includes challenging a will, disputing what is in an estate, arguing over what happens in the event of intestacy, and disputes over what should happen to bodies and ashes after death. And it's this last issue which I've been invited to look at today. I'll just say from the outset, because we've obviously had a bit of a run through before we started as to who's here. I know there's a mixture of what I would call public people and lawyers. And this is a talk that's aimed at the general public rather than lawyers themselves. If you want a more in-depth consideration of the statutes, the procedure, the relevant case law, and effectively a proper legal run through of what to do and how to do it, I can point you in the direction of an excellent book. And I say, next slide, please.
Oh, why is that not working?
Which isn't me. I don't do the slides.
No, I'm doing the slides. Just click. Might be because you're on the chat. There you go. Thank you.
There you go. It's an excellent book called A Practical Guide to the Law in Relating to Control of the Body and After Death. It's available from Law Brief or Amazon, and I have to say it was worth writing this book just so that I could impress my children, albeit very briefly, with the fact that their mother features in Amazon. But I'm not saying that just to plug my own book. It is a genuine signpost to where you can get more in-depth technical legal help, because this seminar is essentially an overview of the subject. I also have to say, obviously, at this point, that nothing in this seminar should be taken to be legal advice. If you have a dispute over a body or indeed any other form of probate, I would always advise you seek proper professional help for your particular problem. I'd obviously advise a lawyer, but Julia might give you some alternatives. So basically, that's the introduction and the disclaimer that you can't now rely on anything I happen to say to you over the next 20 minutes. I'll turn to the talk itself. And the important thing to remember at the outset is that there is no right of ownership in a dead body. Nobody can say that body is mine, and therefore I decide what to do with it. But there is a duty at common law to arrange for the proper disposal of a body. And the person who has the duty to dispose, so to speak, is the person who can call for the body to fulfill that duty. So essentially, you're the person who has to have control. So you can phone up whoever's got it and say, right, I'm the one who's got to be in charge of dealing with it. So please, can you release the body to me so that I can make the arrangements? So when you have any dispute over a body, and of course, those disputes are normally whether it should be buried, whether it should be cremated, where it should be buried or cremated, that sort of thing. The first question you need to ask is who has the duty to dispose of the body? So whose job is it? And the answer to that question is, it depends. And as is the case with so many probate disputes, it is a lot easier if the deceased left a will. And you can see there on your screen the title, Who Has the Duty? And number one, where you have a valid will, and for the purposes of this talk, I am going to assume that your will is valid. If you want to challenge a will and therefore challenge the status of the executor, go and see somebody and get some legal advice. For the purposes of this talk, I'm going to assume we have a valid will. In those circumstances, the person with the duty to deal with the body will be the executor who is named in the will, or if more than one, then the executors, plural. It is that straightforward. They are named. The will usually, hopefully, contain their addresses, so you know how to find them. And because an executor gets their authority and their power to act from the existence of the will itself, the right of an executor to call for the body exists from the moment of death. They are in charge, and if you want to challenge what they are doing, then you will need to challenge their status as an executor. Where you don't have a will, I'll come to it later, you can in fact challenge it. You can say, well, they are the executor, but actually we want to do something different. But you can also challenge their status as an executor. Where you don't have a will, it is more complicated. Although people generally use the terms executors and grant of probate to apply to all dealings with an estate, In fact, executors only exist where you have a will. Where you have an intestacy, that is, there's no will or there's no valid will, the person dealing with the will is not technically an executor, they are an administrator, and they apply for letters of administration. Once an administrator has those letters, which come from the same place as a grant of probate and they look very similar, they are in the same position as the executor and they have a duty to dispose and therefore the power to call for a body. Now, if you've been paying attention, you'll have noticed I said an administrator has the power once they have their letters. But anybody who has been dealing with any form of probate dispute, or indeed probate full stop, knows that it can take weeks, if not months, for you to get to your letters of administration. So in fact, it's quite rare in a body or funeral dispute that an administrator with letters can run around waving their letters in the air going, I've got letters, I've got the authority. So where you have an intestacy, but you do not yet have any letters, the person with the duty will be the person or persons with the highest right to take out the grant as prescribed by law. And that is, next slide, please. The following order. So it starts at the top, and these are the people with the most entitlement to the letters, so the person with the most authority to deal with the body. Spouse or civil partner, then children or their children if they died, that's the died, it should be they died, if they died before the deceased. So basically, if you have, say, deceased grandma and she had 3 children, children 1 and children 2 are still alive, but child 3 predeceased her. The people in that second category are child 1, child 2, and the children of child 3. The third category are parents, then it is siblings, same principle, or their children have died before, then it is half siblings, then it is grandparents, and then it is aunts and uncles. And one thing that you may have noticed is that this list does not contain the words next of kin, because there is no such thing for the purposes of the law around probate and inheritance. It's just not a thing. It also doesn't contain the phrase common law wife, common law husband, for exactly the same reason. Just as a long-term partner or cohabitee does not inherit under intestacy, so too they have no right to apply for letters of administration. And you either fall into this list or you don't. And if you do, then your right to the letters and therefore your right to claim the duty and have the power depends on where in the list you are. The higher you are, the greater your right. Effectively think of it as a game of trumps, top trumps or poker or something like that. Spouse beats child, child beats parent, that sort of thing. So now you know who's got the duty and therefore the right to make a decision. It's the executor or the person at the top of your list. But what if you want to challenge the decision of the person with the power? Or what if the dispute is between people with equal right to that power? Most commonly, the disputes surrounding bodies are parents when a child dies, or they are the children of the deceased, either because they've all been named as executors or because they're all equally entitled under intestacy, and you've got 2, 3, or 4 people, all of whom want different things, or they split into 2 camps with half wanting one thing and half wanting the other. In these circumstances, you have 2 choices. You can talk and reach agreement as to the way forward, and this is the route that Julia will be talking to you about. Or you go to court and you get an order to decide who should have the power, because the court has the ability to say that person X has the power and the right, even if person X isn't actually the person at the top of the tree, or even if person X doesn't actually have the right to have letters of administration at all. Effectively, the court can overrule the trump card that someone else has already said. So I don't have time today to go into exactly how you do that. But what you can take away from this talk is that if you do go to court, it generally works out like this. If there is one person with the right, so for example, one named executor, one surviving spouse or civil partner, then the court usually won't intervene. It won't interfere. It'll say, look, you've clearly got one person, that's the person who's going to make the decisions. However, if there are circumstances which means you should challenge it, or there is more than one person with an equal right, the court will give the power to one person after considering the matters on the next slide. And what the court will take into consideration are the wishes of the deceased, the reasonable requirements and wishes of the family who are left to grieve. In the event of a dispute over location, the location with which the deceased was most closely connected, and perhaps the most important, that the body be disposed of with all proper respect and decency, and if possible, without further delay. So say, for argument's sake, you have four children of the deceased, 2 on one side, 2 on the other, and 2 want the person burying in cemetery A, and 2 of them want it burying in cemetery B. For example, cemetery A might be where the childhood home was, where they all used to live, and cemetery B is where actually the parents retired to, which is miles and miles and miles away. They both have equal rights. Both of these camps have equal rights to the letters of administration. And so the court will need to, if they can't reach agreement, they've been to see Julia, it doesn't work, the court will then look at, well, has the deceased expressed any wishes? You know, is there anything written down? Is there evidence from anybody that says, well, actually what she really wanted to do was go home and she wanted to be buried in her childhood home, that sort of thing. If not, what about the requirements of the wishes of the family who are left to grieve? In fact, is there anybody who still lives in the location of the old family home? Or in fact, is everybody living closer to where mum actually died? Which is the more convenient location, and what are their reasons for wanting them burying a particular place? If not, then the location. For example, mum might have lived in that first house for sort of 50 years, and in fact has only been living in the second location for a couple of months. Or it might be actually that was a location during their childhood that they lived for convenience. And in fact, all they really, really wanted to do was live by the sea. And in fact, that's the place to which they're most closely connected. And the final one, sometimes is an issue, sometimes isn't. But for example, are both of you proposing to bury as quickly as possible and with respect and decency? The last one tends to fall into play when you have an international element. So where one party wants to bury in the UK and somebody else wants to take it abroad to bury. Are there provisions in place to take the body out of the country to have it buried, or is actually going to be a delay of several weeks before you can ship the body out of the country? So they're the things the court will look at, and then the court will make a decision. If you go down the court route, you will obviously need to issue court proceedings, and there will be a hearing. It will be a full hearing, as you see in court on the television. There will be evidence, there will be opening, there will be lawyers, there will be a judge. It will take time. And of course, this is all time before you can put your loved one in the ground or take them to the cemetery. And you must remember the person who loses will usually be ordered to pay the costs. A lot of people think, well, it's a dispute over an estate. The estate will pay the costs. No, it has been described as hostile litigation of the usual kind. And that means that the individual who wanted mum burying somewhere else, if they lose, they will pay all of the costs. Which is one reason why Julia will tell you to mediate. Keeping all family people happy is also another reason. I'm not going to say anything further about that. There are cases that can and should mediate, and there are those that simply won't ever be settled that way. But if you do go down a legal route, I would always advise, or your clients are looking at going down the legal route, I would again always advise them to find a lawyer. And one of the reasons that is to help you focus upon the right question, which is who should have the duty and therefore who should have the power. The court itself will not get involved in making decisions about whether a person should be buried or whether a person should be cremated, or where, or when, or what colour the flowers should be, or which hymns or songs someone should have played at their funeral or their celebration. The court won't determine those matters. The court will determine who has the power to make those decisions. The court won't say, actually, I think the flowers should be red. It will say, well, person A thinks they should be red, person B thinks they should be yellow. I'm going to give the power to person A. And that way the decision is up to person A. And you should also remember that the court has the power to grant an injunction to prevent anybody from dealing with the body until that dispute has been resolved. So you'll sometimes find that bodies are being held in a morgue or indeed at a funeral home until this has been to court and everything is all sorted out. Now, the reason I've spent so long telling you about who has the power is because that is pretty much the answer to most of your disputes. So, should the deceased be buried or cremated? Well, who's got the power? That's the person with the duty. That's the person who has the power to decide. Where should the deceased be buried? Ultimately, it's a decision for the person who is given the power and the duty. Unfortunately, full circle funerals are booked for the day you want to have your funeral. You need to think the unthinkable and use a different funeral director who decides whether to use them or simply wait until they're available. Again, go back to the person who has the duty to dispose. They have the power to decide. Again, flowers on the coffin, when the cremation should take place, how the body should be transported. These are all decisions given to the person with the power. And whilst the funeral itself is better described as a ceremony, because of course you don't need a funeral to dispose of the body, and technically you don't need a body, I think, to have a funeral. You might want to call it a celebration of life, but you can do both of them without the other. The reality is the two do go hand in hand, and the courts have therefore considered the person, because the person with the duty to dispose of the body gets to decide how to dispose. This also includes organising the official funeral, so to speak, and their right to decide upon the mode and place for disposal of the body will only be interfered with if it is unreasonable. Of course, one solution will always be to have two funerals. That is something I have seen, one with a body, one without. I have also seen it where the body is taken to both. It is taken to one, then it is taken to another, and it is then cremated or buried the following day. That was something we negotiated. I'm not sure a court would do that, but certainly that is, you have to be somewhat creative. And remember, of course, everybody's upset, everybody is grieving. If you can make it as easy as possible for people, that is generally the best option. So that's in relation to bodies, but what about ashes after a cremation? Now, having listened to me for the last 20 minutes and applying some logic, you might be forgiven for thinking that because there is no property in a body, and the ashes which you are given are the remains of that body, the same rules apply. The person with the right to decide what happens to the body also gets to decide what happens to the ashes. But of course, it's not as straightforward as that. The person who gets to control the ashes is not necessarily the person who had the right to control the body, because they've dealt with it. The body has gone. It has been taken away. It has been burned. It is no longer effectively in existence. The person who then controls the ashes is by and large the person who signed the cremation forms. And this is because although you cannot own a body, if a body has acquired different attributes through the application of skill, such as dissecting the body or preserving the body, it becomes property and it can be owned. And this is why if you were to go to a museum and steal body part exhibits, or an anatomical specimen from a hospital, you can be convicted of theft. You can't rely upon the defence, well, nobody owns the body and therefore I haven't actually done anything wrong. Once application of skill has been applied, it is no longer a body that can't be owned, it is a thing that can be owned. And in a similar vein, ashes have been deemed by the court to be property and therefore they can be owned. So let's look at the cremation. An application for a cremation is made by way of prescribed forms by either an executor or a near relative who is aged 16 or over. And a near relative, next slide please. A near relative, oh, so ashes, I've missed a slide out. Keep going. Sorry, I should have said next slide please. I started talking about ashes. There you go. A near relative is defined as a widow or widower, a surviving civil partner, a parent or child, or any other relative usually residing with the deceased. In one sense, that's obviously quite a wide definition. You know, great uncle Charlie residing with the deceased would count as a near relative, but also it's quite narrow because if you're not a surviving civil partner or widow or related, you don't fall into this category. So an application can also be made by some other person if the medical referee is satisfied that this applicant is a proper person to make the application and is satisfied with the reason given for the application not being made by an executor or a near relative. And an obvious answer to that is where the applicant is a cohabitee. Someone dies intestate, so there isn't a will, he's not the executor, but they are the cohabitee. They are the person who has been living with the deceased for the last 30, 40, 50 years. They don't fall into the category of near relative, but the medical referee is going to be satisfied, usually, that they are the person who is appropriate to sign the cremation forms. And the issue of who signs those cremation forms and fills them in can be very, very important in an ashes dispute, because following the cremation, a cremation authority must either, next slide, please, they must either dispose of the ashes in accordance with the applicant's instructions, or where there are no instructions, or the ashes are not collected in accordance with those instructions, may dispose of the ashes by burying or scattering the same. So if the person who signs the forms says that the ashes must be released to Great Uncle Gordon, rather than say the children of the deceased, then that is what the cremation authority must do, because it says on the form, the applicant's instructions are released to Great Uncle Gordon. Daughter turns up at the cremation and says, no, sorry, you can't have them. They've got to go to Great Uncle Gordon. So that's where they go. So if you think there's going to be a dispute over ashes and you are going to be involved in that, the best advice I can give you is to make sure you or somebody who is sympathetic to you is the person who signs the cremation forms. If you're the person on the other side, you might want to think about resolving your differences before the cremation actually happens, because experience tells me that actually once somebody has the ashes, it can be very difficult to get them back. And of course, once they've been scattered or they've been buried not in an urn, of course, retrieval is impossible. Assuming, however, that Great Uncle Gordon hadn't scattered them, but he has put them on the mantelpiece, which of course is in books and films where everybody keeps ashes. In reality, I'm not convinced about that. I know we kept my grandfather in a box under the stairs for 2 or 3 years before we scattered him. But there you go, mantelpiece is where they're going for the purposes of this dog. What happens to them? Where you have 2 different family factions wanting to deal with them differently. Now, because the ashes have been deemed to be property, the person holding them does so on behalf of all of those who have an interest in the ashes and what happens to them. And essentially, Great Uncle Gordon is holding them as a trustee, so he can't just make his mind up based on what he wants to do. He has to take into account all of the relevant circumstances, the various views of the various factions, and he has a duty to act reasonably and rationally. 2 words which, again, from experience, are not always at the forefront of minds when arguing over ashes. I can say without hesitation that in these circumstances, the best solution is for the parties to sit down and reach a compromise, if necessary, by mediation through someone like Julia, or indeed Julia herself. Of course, you don't have the time pressure with ashes. You tend to have a time pressure with bodies because the body is doing what bodies do before they are dealt with. But ashes can happily sit on a mantelpiece or under the stairs for several months or indeed years. But mediation with Julia will be quicker. It will also be cheaper, both in financial and emotional terms, because the only alternative, if you cannot reach agreement, will be a court hearing in the Chancery Department, dealing with effectively a judge and barristers and solicitors who specialise in trusts disputes. And such hearings are never cheap and are not known for bringing disputing parties together. So having urged you to consult Julia if you are arguing over your ashes, it seems an appropriate time to hand over to Julia.
Thank you very much, Nicola. Yeah, thanks, Ruth. So, yes, thanks for giving me lots of lovely plugs there, Nicola. I am a mediator as well as a lawyer, and I set up my practice Dove in the Room about 5.5 years ago now, having been a litigator for many, many years before that. And I got myself to a point where, whilst I've always wanted to be a mediator, as a litigator, as the years went on, I got, to be honest, more and more disillusioned with the litigation process. And I was drawn more and more to wanting to be the person sitting in the middle, trying to help people to just work out the disputes in a slightly better way. I'm not going to talk for that long. I'm conscious I want to leave time for questions and discussion at the end, because I think there's lots of interesting people in the audience with lots of different backgrounds. So I will just say that I have actually never mediated or dealt with, as a lawyer, a dispute over a body. Most of what I see tends to be disputes about ashes. If you could just move on to the next slide, please. ashes disputes, I think, are probably the most common because they tend to come up in multiple probate disputes and inheritance disputes. And there is often an argument about what to do with the ashes. I'll just tell you one story before I carry on, which has always just sat with me. I had an inquiry passed to me by a central London lawyer who had been contacted by a lady, a daughter of the deceased, who had contacted the lawyer wanting to know whether she could take out an injunction to do with the funeral and ashes. I think she was in a bit of a state. The lawyer sort of said to me, look, could you have a chat with her and see if there's anything you can do? I decided to speak to the funeral director first to try to get an understanding of what was going on in this family. There was the daughter of the deceased, who was the potential client of the lawyer. Then there was, on the other side of the dispute, the stepmother and her brother. And I think it was the stepmother and the brother who were the clients of the funeral directors, and they were the ones who were taking control of the funeral. So obviously the daughter, the sister, felt very much on the outside. But the dispute was about the ashes. And after quite a long chat with the funeral director, getting an understanding of what it was all about, I then spoke to this daughter just to see if I could just touch base and explain to her that, you know, what we could do. And in that conversation, I managed to just get her to actually see that there was a way to resolve this, which was simply that she got a keepsake urn. The ashes were split, and she got a keepsake urn, and she got a portion of the ashes. Before she joined the call with me, she thought that it would be some little tiny, ugly sort of, you know, almost like a Tupperware pot or something, I think. And I managed to get her to see that actually these keepsake urns are really quite beautiful, and that it wouldn't be that small, and that actually it would be fine. And in a really quite a short conversation with me, she just shifted suddenly. And I remember it really clearly at the end of the call. She just said, oh, right, okay, well, if it's like that, then that would be fine. And it really wouldn't, it's not worth it, is it? So she went in a very short space of time from probably panicking and thinking, what else do I do? Where else do I turn? A lot of people often think, I'll ring a lawyer, and that's understandable. You want to know what your rights are and what your options are. But she went from talking about injunctions, probably got a very high quote, I would imagine, from Central London lawyer as well, to a conversation where, you know, I just listened to her and just got her to see a slightly different perspective. And actually, she just decided not to go ahead. So a sort of a conversation can be very powerful. Obviously, that one never got off the ground. There is obviously, if things are more complicated and more protracted, then mediation is a good way forward. If you could please move on to the next slide. Most of the time, mediation will be when there's already lawyers involved. I'm conscious that there's lots of different people here on this call, and so I just thought it might be quite useful actually to just describe what mediation is, because there are a lot of misconceptions out there. First of all, it's not meditation. I have had people get that mixed up all the time. And it's also not what, if you saw it, Mr. Bates and the Post Office portrayed as mediation, because that was pretty shocking. That, if anyone saw it, was just definitely not mediation. If you could move this slide, by the way, Ruth, is in 3 bullet points. So if you could just do one click. So this is the sort of classic definition of mediation: a voluntary confidential process in which the parties to a dispute can meet with the help of a neutral intermediary to work out their own settlement. And the crucial thing with this is that they are working out their own settlement. It's not me as the mediator making a decision for them, or making, you know, just telling them what to do. I help them to have a conversation and to work out a way forward together. Slightly more, if you come on to the next definition, and I'm conscious this is quite wordy, and you will get these slides afterwards, and so you can digest it, but this, you can't really define mediation. And Ken Cloke is a very well-known, famous mediator, and this is his non-definition of mediation. An alternative approach is not to try to define it, because the nature of each mediation is uniquely determined by the complex, subtle, changing nature of the unique conflict it is meant to address, and consists of all possible ways of understanding and responding to it that might help the parties reduce, resolve, let go of, and prevent it, none of which can be known or relied on to succeed in advance. We learn what mediation is in each moment by being present with it, by watching how it shifts and turns, picks up, disguises and discards them, leads us down blind alleys and into hidden chambers no one imagined were there. It is an exploration of an adventure and has a magic in it that will never be defined. I love that definition. I only came across it very recently, but it really does. I mean, I will explain in a minute how flexible mediation is, and that sums it up nicely as to what, you know, how flexible it is and why it has to be flexible. My third and final, one more click please, definition of mediation, however, is a conversation that should have happened a long time ago. And I use that quite a lot of the time, because I find that people often come to mediation just not really knowing how it's taken so long to get there. If we can just move on to the next slide, please. So how can mediation help in funeral disputes or disputes about a body? Obviously, as I said, people often do go first to a lawyer, entirely understandable, but it can be considered before litigation or before any conversation with a lawyer. So there's nothing to stop people getting mediation off the ground with no lawyers involved. It can be arranged very swiftly, and it can work very, very well for time-sensitive matters such as these. But most of the time, the cases that I see do already have lawyers involved, and it is the lawyers that suggest mediation, and it is the lawyers that persuade the clients to try mediation. These days, since COVID, it is a very flexible process, and it can be arranged in various different ways. So Zoom works very well for mediation, but it can also still be done in person. People do tend to like Zoom because it means they don't have to be in the same building as the family members who they have fallen out with, and they can often feel more comfortable. So Zoom mediation is possibly slightly less stressful for clients because they can do it from the comfort of their own home. And as Nicola said earlier, it is quicker and more cost effective than going to court. And most of the mediation that I do is what's called shuttle mediation, where I will be moving from one room to the other. There's no requirement for clients from opposing sides of a dispute to be in the same room as each other during the mediation. But there is power in a conversation, and I am not a believer in mediations starting with a joint session, as the traditional process sometimes does in these types of sensitive family inheritance disputes. But I always say to clients coming into mediation, whilst we may not start like that, let's just keep an open mind about whether actually that is somewhere where you might go during the mediation. And I have another story of a case that I mediated that has been going on for 5 years. And it was a dispute about ashes. It had lawyers involved for 5 years. And I'm conscious, actually, I think the firm that was involved in this case, I think, is on this call. I'm not sure the lawyer who did it, though, is. The husband had died, and there was a grieving widow, and there was a grieving mother on the other side of the dispute. There was also the grieving widow, that the son of the deceased was also sort of involved, sadly involved. That son was autistic and had developed a really, really quite strong attachment to his deceased father's ashes, which the mother told me that when they went on holiday, he would take them with him in the car and things like that. It was a really, really sad situation. And I think had become all the more difficult because the son, who was quite young, had been involved and knew what was going on and was aware of the dispute between his mother and his grandmother. And needless to say, the family had been torn apart. There was no relationship. They weren't talking to each other. It had gone on for a very long time. One of the firms who are here today, I think, had been trying to suggest mediation for quite some time, and it was the other law firm who was possibly not quite as collaborative. And I do recall reading in the bundle, in response to the proposal to mediate, the lawyer said, we've effectively been mediating this case for the last 3 years to no effect. So I don't know what you think, why you think mediation will solve anything. I had my head in my hands when I read that. But anyway, mediation did eventually get arranged. And it was a dispute about where, whether the ashes should be split or where they should be scattered or kept. And actually, in the pre-mediation call, I established that, in fact, the ashes had already been split and half of them had already been scattered at sea. And I became aware in that call that the other party didn't actually know about that. So it had gone on for nearly 5 years, and actually there was a complete misunderstanding about what had actually happened with these ashes, which was quite astonishing. But that's the limitations of litigation sometimes. It then transpired, to sort of cut a long mediation story short, that given that I established that those ashes had already been split once, it was quite easy for me as the mediator at the appropriate time during the mediation to say, have you thought about them being split again, given that they'd already been split? If one of the parties in that mediation had proposed that, it would probably have been dismissed out of hand. Because it had come from me as a neutral person and I had suggested it gently, it landed in both rooms as something that they were both prepared to consider. The next thing that I did in that mediation was to actually get them together in a virtual room on Zoom. We had a conversation. There were no lawyers present. It was just me and the mother and the widow. And we had a conversation that lasted, from memory, about 10 minutes. And in that conversation, we worked out a way forward. And not only did we work out a way forward in relation to the ashes, and they were split again, and they each did basically what they wanted to do with the ashes, they also started to reconcile the relationship, and the outcome of that was that the grandma and the grandson were going to start seeing each other again. So it was quite a beautiful ending, and quite a powerful story, I think, of unfortunately how litigation can get very out of hand, and can sometimes just get very protracted, and just, at the right time, mediation can just cut through a lot of that. We can just move on to just my last slide, and that is just to talk about one other thing, just to think about. Mediation is a sort of a traditional process, but there is also, a lot of these families that we are talking about, you won't be surprised to hear, I don't like this word, but they are quite dysfunctional, and they have got very sort of, problems that go back in the families a long way. Relationships are generally, not great, to say the least. There are some cases that are suitable for something called family conflict coaching, and that is generally where there isn't a dispute that could go to court. But nevertheless, there is a dispute within the family about something to do with inheritance, or whether it be something to do with what we're talking about. And you can get a mediator to help families on that basis, where they're essentially just working with that family over a period of time. It's not just one big day. It's very informal. It can take weeks or months. It's very flexible, the process, and you can work with families on more than one dispute. So the issue may be, what are we going to do about the ashes? But actually, there's a lot more to it. And actually, it's an area to consider with some of these families where, it may not be that there may not be a legal dispute. They may not need lawyers. And actually, if you just sort of probably just bear that in mind when you're talking to some of these families, and just sort of say to them, you've thought about, yeah, someone's just put, it's never just about the ashes. Exactly. That's the point. There's always multiple layers to it, and family conflict coaching can really, really help with that.